Well, good evening and thank you for joining us. Let me see if I can get some glare out of the video here. Forgive me, these live videos are always interesting. While we're waiting, I'd like to introduce myself. My name is Michael Gault. I'm an eminent domain attorney with Bell, Carrington, Price and Gregg. I'm going to enter my name, email address, and direct phone number in the chat box now. So throughout this live town hall, I'd invite any of you that are here watching live to feel free to enter any questions that you may have in the chat box. But some of those naturally I won't be able to address in a public forum. And so I would like to invite any of you whose questions I can answer during this forum to feel free to reach out to me at the information provided or at our website, bellcarringtoneminentdomain.com. There are a number of ways to reach out to our team to schedule a consultation directly through our calendar app. There's a fillable form where you can reach out and connect with our team directly. You could also find all of our names and email addresses so that you can email anybody on our staff that can help you through this impact. That being said, Michael Gault, Bell Carrington, and I appreciate those of you that are here live and those of you that are going to watch this town hall at a later date. If you're here with us this evening, you know that we're talking about the 127 widening project near Hickory. This road project, like many others across the state of North Carolina right now, is a major undertaking. This project has a budget of nearly $54 million. A large portion of that, nearly $25 million, is dedicated to right-of-way acquisition. What does that mean? Well, we're taking what was in many places a two-lane road and widening to a four-lane road with a 17.5-foot, on average, raised median in between, a shared use path on one side and a sidewalk on the other. And so anytime there is such a significant widening and improvement project of an existing roadway, naturally property, which is currently private property on both sides of that existing roadway throughout the project's footprint, will need to be acquired for a public purpose. The government, in this case, the Department of Transportation, has the right, under the legal theory of eminent domain, to be able to take private property for a public purpose to complete projects like this one, particularly infrastructure projects and road improvements, generally speaking, fall within that definition. As many of you know, this project is some 20 plus years old, at least in its inception. It has taken that long for the project to become a reality. And back in the spring of 2024, the spring of this year, we know that the project had a final phase outline and plan in place. The preferred alternative was released to the public, and likely many of you attended public hearings or at least got some information from those public hearings to know that your properties may be impacted. Now, here we are in late 2024, and all of the information that we have shows us that the right-of-way acquisition portion, the first phase that will impact you as landowners that are hurt by this project, is set to kick off in early 2025. Naturally, anytime you're dealing with government projects, those timelines can vary. Usually, if they vary at all, they're pushed later, but we would expect for the initial phases of right-of-way acquisition to kick off early next year. What does that look like for you as a landowner, and what does that mean for you as a landowner? Well, if your property will be impacted, initially you're likely to be contacted by either a right-of-way acquisition agent or an appraiser who will do some preliminary steps, including an inspection and an appraisal to determine what the impact to your property might be worth, what it might look like, and how it might impact you. On projects like this, the potential impacts to property owners varies drastically. You could have what we call strip takes, which is just a small portion of property in a straight line across the currently existing frontage that doesn't impact the structure, that doesn't impact access, that doesn't impact the value of the property much at all. Or you could have total takes, meaning that the impact is so significant that entire businesses or homes or other improvements might be impacted and lost as a result of this road improvement project and road widening project. And then naturally, there are dozens, if not hundreds, of other types of impacts in between that impact parcels, be they residential, industrial, commercial, or otherwise. And that those impacts vary from changes in access, loss of hardscaping or landscaping, loss of signage, loss of parking spaces from if anybody has a commercial or an industrial property that relies on parking, something you have to be on the lookout for. And so those impacts are variable across the entire spectrum, and that's where our team comes in. We specialize in representing landowners across the Southeast and the Carolinas, Georgia, Alabama, and Tennessee. And I have the pleasure of managing our team of attorneys and staff that are fully dedicated to representing landowners in cases like this across all different types of property ownership. We are well versed in identifying those impacts. So oftentimes you may see that the DOT or the government entity, whoever is taking property, will certainly make you an offer for what they're taking from you. Oftentimes you'll find that they miss something. They might miss a particular damage, or they might undervalue an acquisition for one reason or the other. And so that's where our team comes in. We help make sure that we can identify those damages. We help argue and advocate and ultimately negotiate on behalf of our landowner clients to make sure that they receive just compensation. The government that like we talked about a minute ago, they have the right to eminent domain. They can take property for a public purpose. You, as a landowner, you have a right to just compensation. That's your largest and most important right in cases like this. That just simply means that the government has to pay you fairly and adequately for what they take from you. Unfortunately, that's never simple to identify, and it's certainly not simple to get once it's identified. And that's our focus. That's our specialty, and that's what we're really good at because we're dedicated to it 100% of the time in our practice. I can't begin to address numbers or offers. As you know, those offers and numbers change drastically depending on which property and which impact that we talk about, but I can tell you two things for certain. At Bell Carrington, we have some proprietary software that will allow me in real time to pull up your property by name, address, parcel number, and I can tell you while we're speaking on the phone during an initial consultation what the impact to your property might look like. I can be able to tell you based on our GIS overlay, if we're dealing with a strip take or something more serious, how that might impact your property and how we might be able to help. Those consultations are always free, no obligation, no charge, no pressure. This is what we do, and we have a team of folks standing by at the information. You can reach me directly at the information in the chat box. Just call me up, give me your name, address, or parcel number. I'll be happy to take a few minutes, or have someone on our team take a few minutes to explain to you what we believe the impact to your property might look like, how we might be able to help, no charge, no obligation. The second thing I can tell you is that landowners, particularly residential landowners, but even small business owners, are often concerned about attorney's fees. Will paying some outrageous retainer or hourly rate eat up any difference that this lawyer might be able to make for me in these DOT negotiations? Fortunately, at Bell Carrington and our eminent domain practice, we operate on what's known as a contingency fee basis. That just means that our fee is a percentage of the amount of just compensation ultimately recovered on behalf of our clients. And it's not calculated on total money or the total amount offered. It's calculated essentially on what I would term new money, or the difference or the delta between the initial offer and the ultimate amount received. And so for that reason, there's very little financial risk to a landowner to have a consultation with, and ultimately to hire a lawyer with like Bell Carrington with that fee structure in place. Our interests are certainly aligned in that way. And ultimately, if we're not successful in identifying and recovering just compensation for you over and above the amount offered, then the client is responsible for no attorney's fee to our firm in this particular practice area. So, it's one of those deals where it makes sense to at least have the consultation. Let's identify if your property is one that's impacted, one that I think that we may be able to help you on, one where it makes sense for both of us. And certainly if it is, then we'll be glad to advise you with the next steps. Once we are engaged, we take over all conversation and consultations and communication with any condemning entity. We make sure that we communicate with the appraiser, with the right-of-way agent, and ultimately, if the case goes to the next step in the process, which is condemnation, then we represent you through that litigation as well against the Assistant Attorney General on behalf of the state who picks up the case to represent the DOT on their behalf. These cases can go months. They certainly can go years in the worst of cases. That's not typical. It depends on each individual parcel, how complicated the impact may be, how much or what kind of money are we talking about, and how quickly does the government move. Oftentimes, those are some of our longest delays. But just to recap, and while I'm doing so, if you have any questions that you'd like to type into the chat box, feel free to do so, and I'll be glad to answer them if I can. We are here to help you as landowners. That's what my practice group is dedicated to. We do that across a number of states focused in the Southeast. North Carolina is among our largest, and one that we focus on primarily right now. With the number of infrastructure projects that are going on across the state, I've seen major projects like this recently, both in central and eastern North Carolina. And we know that the impacts to landowners can be significant, particularly in growing areas like Hickory. You're going to have some serious commercial impacts. You're going to have some serious light industrial and maybe even some serious residential impacts. And so regardless of which category you fall into, we would welcome the opportunity to speak with you just to be able to have that conversation about your property, your impact, and to see if it's one where we may be able to help. In conclusion, Michael Gault, Bell Carrington, I appreciate you joining us. I'm not seeing any questions in the chat box, but if you feel more comfortable emailing me directly or giving me a call, please do so, and I'll be glad to get back with you or have someone from our team do so as quickly as possible. Thank you again for your time. Have a great evening.